I'm Mike Hackard with Hackard Law. Trustees hold a position of enormous trust, literally. They're expected to act in good faith, protect the beneficiaries, and manage assets with honesty and care. But what happens when a trustee starts putting themselves first, when personal interests take priority over duty? In Sacramento and across California, that's when lawsuits begin. At Hackard Law, we represent clients throughout Northern California who are facing serious trust disputes, cases where a trustee's breach of the duty of loyalty has cost families money, time, and peace of mind. So, what exactly is the fiduciary duty of loyalty? It's simple and powerful. Under California Probate Code, Section 1602, a trustee must administer the trust solely in the interest of the beneficiaries. That means no self-dealing, no conflicts of interest, no favoritism, and absolutely no using trust property for personal gain. Even if a trustee means well, the moment they benefit themselves over the beneficiaries, they've crossed the line. In Sacramento, we often see trustees get into legal trouble for a few recurring reasons. First, self-dealing. That's when a trustee uses trust funds or property for themselves, maybe selling assets to a friend or relative below market value, or borrowing trust money. Second, favoritism. When one beneficiary gets special treatment, faster distributions, free use of property, or private communication, while others are left in the dark. Third, concealment. A trustee who hides documents, delays accountings, or refuses to answer questions isn't being loyal. They're being evasive. And finally, conflicts of interest. Hiring their own business to manage trust assets or paying family members from trust funds are red flags that courts take seriously. When these breaches happen, the process begins in the probate division of the Sacramento County Superior Court. Beneficiaries, with the help of a trust litigation attorney, can file a petition asking for an accounting, trustee's removal, or repayment for losses caused by misconduct. At Hackard Law, we build each case carefully, gathering records, depositions, and financial evidence to show how and when the breach occurred. And often, the pattern is clear. In one Sacramento case, a trustee was collecting rent from a duplex, but only reporting half of it. The court ordered restitution and removed him from his role. In another, a trustee sold real estate to his girlfriend for well below market value. The sale was voided for breach of loyalty. And in yet another, silence told the story. A trustee who ignored accounting requests for years was eventually removed by the court. So how can beneficiaries protect themselves? First, know your rights. You have the right to a copy of the trust, annual accountings, and equal treatment. Second, document everything. Save emails, messages, and written requests, paper trails, win cases. And third, talk to an experienced trust litigation attorney. These cases are complex, and Sacramento probate courts have their own rules, timelines, and expectations. When a breach is proven, courts can remove the trustee, order repayment, void shady transactions, and even make the trustee pay the beneficiary's legal fees. The fiduciary duty of loyalty isn't just legal language, it's the foundation of trust itself. When that trust is broken, the consequences are real, emotionally and financially. At Hackard Law, we stand with beneficiaries who deserve honesty, fairness, and transparency. If you believe your trustee has crossed the line, let's talk. Because loyalty shouldn't just be expected, it should be enforced.